Federal Court of Appeals of Tennessee is now in session.
Thank you, Mr. Hibner, and thank you to both counsel who've agreed to conduct your oral arguments via live streaming video conference. Let me remind you, in addition to this being live streamed so that anyone can observe it today while we're engaged in the argument, in a week or two, the recording of this will be posted on the Administrative Office of the Court's website for you and the public to view at their leisure. Judge Andy Bennett, Judge Neil McBrayer, and I, Frank Clement, are pleased to be your panel. We will conduct the argument today in the same fashion as if we were in the courtroom, all of us there together. Both of you have 15 minutes. The appellant does have the right to reserve up to 5 minutes for rebuttal. Unless there are any announcements, Mr. Hibner, call the case.
Jim Daniel Story Jr. versus Heidi Rebekah Nussbaumer-Story.
All right, please proceed.
Good afternoon, Your Honors. Nathan Hunt. I represent the appellant, Danny Story, in this matter. I would like to reserve 3 minutes for rebuttal at this time.
Thank you.
Thank you. Your Honors, I represent the husband, Danny Story, in this matter. This was a 13-year marriage. The parties have one minor child. It's 12 years old. Your Honor, the main issues on appeal before the court essentially are the award of alimony and solido by the trial court to the wife. That is the main issue that we're here on appeal today. The parties were able to resolve the parenting plan for the minor child prior to the divorce trial, so that is not at issue today. The main facts that are at issue here are whether or not the husband's income would support the amount of alimony that was awarded to the wife in this case. The facts at trial was husband is a loan officer, wife is a licensed nurse practitioner, wife has a master's that she received in nursing. She has a specialty in women's health, and her master's degree is from Vanderbilt University. Husband testified at trial, and it was essentially unrefuted that he makes approximately $100,000 a year as a loan officer, and that's what he expected to make in 2019 at the time this case was tried. At the time of the trial, wife had been working as a nurse practitioner for a dietary clinic where she made approximately $60 an hour. She had quit that job 1 week before the trial occurred, but she had been working as a nurse practitioner immediately prior to the trial. The wife was in a car wreck in 2014 that the husband was not involved in. The wife testified at trial that the car wreck had affected the party's marriage, and it also affected her ability to earn her living as a nurse practitioner. Some of the facts in the case, the trial court found to be a little bit confusing based on the testimony of the wife. One issue was the wife did testify that her highest grossing or earning year as a nurse practitioner was 2 years after the wreck. And she testified she earned approximately $80,000 in 2016. So the court asked the wife at trial if that was actually true or if she had her years wrong, because she testified that following 2014, she was debilitated and unable to work, making the same amount of income that she could before the wreck. But then she also testified her highest grossing year was 2 years after the wreck. So the court found that she was able to earn a significant income after the car wreck at issue. The court's order found husband's income to be $7,916 per month. They imputed wife with a monthly income of $4,500 per month. Husband was hit with primarily all of the marital debt from the party's marriage, including paying both mortgages on the marital residence, which was about $2,600 per month. He also assumed 2 lines of credit that the parties had, which was $20,500 per month. The testimony at trial was also that the parties had about $90,000 of unsecured debt that they had incurred during the marriage. Husband assumed the entire $90,000 of unsecured debt. The court found that to be alimony and solido. And then most significantly, the court also awarded wife $1,100 per month of alimony and solido for a period of 8 years. Also, husband was paying $768 per month in child support for the party's minor child. He had to maintain a life insurance policy of $250,000, and he also had to pay attorney fees to the wife of $3,875. So husband had a significant amount of debt that he incurred as a result of this divorce, and was also hit with a significant amount of alimony and solito. In fact, the alimony and solito award over a period of time totals just under $200,000 that husband was ordered to pay. The court did apply the alimony factors in making that determination, and those were set forth in the final decree. And in the brief that was filed on behalf of my client with the court, we addressed those factors and argued that the award of alimony and solito to the wife was exorbitant for the facts that were before the court. Essentially, as the court's aware, the two main factors in determining an award of alimony are need and ability to pay. And in this situation, the argument is there was just no proof at trial to support wife's need for alimony above what husband had already taken as part of the divorce, which was the $90,000 in unsecured debt, which would be about $1,000 per month for a period of 8 years. So wife was already basically receiving that as an award of alimony and solito at the time of the party's divorce. And additionally, wife got another $1,100 per month on top of that. The main factors the court found were wife's ability to work following the accident. And the court did find that her accident affected her ability to work, but the court was very clear in its ruling that it still found she could earn a significant income as a nurse practitioner following the accident, but only imputed her with an income of $4,500 per month, so about $54,000 a year. Even though wife testified at trial, her highest grossing year was following the wreck, where she made $80,000 a year.
Wasn't there testimony that it was kind of a progressive thing and she got worse after that year?
That was the testimony, Your Honor. It would be our position that there was no proof that really supported that assertion. In fact, what the trial court found was up to a week before the wreck, she was working at a dietary clinic where she was making $60 an hour. The court also found very specifically in its ruling, I think it said it's not like she's a construction worker or it's not like she's changing bedpans. The job she was doing did not require a lot of physical or manual labor that she may have been prevented from doing as a result of the car wreck in 2014.
He did impute $54,000 a year of income to her.
He did, Your Honor. It was my client's position at trial that a nurse practitioner with her background, and she testified that she kept her nursing license active and current, certainly is capable of making more than $54,000 a year. And in fact, she testified again that she made $80,000. I believe she actually testified she made $80,000 in 2015 and again made $80,000 in 2016. So clearly the testimony was she was capable of making a significant amount of income above $54,000 a year.
Weren't they homeschooling the child? Wasn't she doing that?
They were, Your Honor. And one of the wife's other assertions at trial was that the parties had agreed to homeschool the child, and that's why she could not work as much as she could before. My client refuted that he had agreed for the child to be homeschooled, and he wanted the child to be enrolled in public school or to attend a regular school and not be homeschooled. And that was why my client's position was that she certainly could make above what she was claiming to make. And again, after the wreck, the child was school age and the wife earned $80,000 a year. So clearly there was a history of wife being able to work following the car accident and to be able to make more than what she was imputed at trial.
What were wife's injuries from the car accident?
Your Honor, wife argued that she had some type of condition before the wreck that was exacerbated by the accident. And I believe, to my recollection, Your Honor, it was something to do with her back. It was a back condition. And she testified that that was exacerbated by the accident. One other interesting point on that, Your Honor, is the wife testified that she had a private disability policy in effect for 20 years, which was in effect at the time of the accident. And I questioned her if she had made a claim under that policy after the wreck, because clearly if the wreck was as debilitating as the wife claimed that it was, then she could have made a claim under that disability policy that she'd had in place for 20 years. And she testified she did not make a claim under that policy.
Was there any proof in the record of what she would have been entitled to had she made a claim under the disability policy?
There was not, Your Honor. The only question I asked her is if she had a private disability policy in effect, and she said that she had and that it had been in effect for a period of 20 years. I don't know.
Is the policy in the record?
The policy was not in the record, but the wife agreed that she had maintained that policy, Your Honor, but it was not made a part of the record.
But I guess we don't know then if it was partial disability policy or full disability, what sort of income would have resulted to the wife as she made the claim, because the policy is not in the record.
I believe that's correct, Your Honor. I believe that line of questioning was more just to show that the award of alimony and solido to wife was higher than what she should have been entitled to receive, because it could have at least supplemented what she already earned as a nurse practitioner, even if she only worked as a nurse practitioner part-time. And really the point of that too, Your Honor, was just to show that if the accident was as debilitating as wife claimed that it was, then she should have filed under her disability policy or for Social Security disability, which she testified she didn't file for either, and made a claim. The amount offsetting what her income was more of a secondary issue. The primary issue was if the wreck was as bad as she claimed it was, she provided no medical proof, but if it was that bad, surely she would have made a claim under a disability policy she had maintained for 20 years. And she testified she had not even consulted with an attorney about making a disability claim. So that was more to the point of going against how serious her injuries were as a result of the wreck, and less about it supplementing her income. And clearly, we believe the record showed that she was able to make a significant income following the accident. And that's what the court found. I mean, the court found that she was able to work and that she was able to make a good income following the accident, but then only awarded her or imputed her with $4,500 per month in income. One of the other arguments we made at trial and in our brief that we filed with the court was just the fact when you look at all of the debt and the alimony and solido that my client makes, it clearly puts my client in a very, very disadvantageous position. He is paying more to the wife than even what she would have received or was accustomed to during the party's marriage. And clearly, I think the case law supports the fact that once the parties are divorced, they're not going to be able to maintain the same standard of living that they maintained during their marriage. In fact, the judge in this case found that the parties lived above their means during the marriage and weren't going to be able to maintain the same standard of living, which is one reason why there was $90,000 of unsecured debt that my client agreed to accept as part of the divorce, because that was debt they had incurred during the marriage because they were both living above their means. My client
wasn't that during a period of time that the husband was unemployed?
The debt was primarily incurred during a period of time where my client was a loan officer and he was, for lack of a better term, red flagged, Your Honor. He did get that red flag removed and he was able to go back to work, but that was during a period of time where my client was making less income. I don't know if he was necessarily unemployed, but he was making significantly less income.
Excuse my ignorance. What does red flags mean?
Yes, Your Honor. As a loan officer, you are obviously licensed to give certain loans, and by having this flag, he was not able to give out loans because of this flag. So obviously as a loan officer, that significantly impeded his ability to earn an income.
But that was removed.
That was removed and he was restored to full employment.
So he's okay.
Thank you.
Thank you, Mr. Hunt. We'll hear from you on rebuttal. Mr. Gursky, the floor is yours.
And please the court, Steve Gursky of the Montgomery County Bar, and I represent the appellee Heidi Story. As Mr. Hunt stated, this is a 13-year marriage. At the time of this trial, Ms. Story was 44 years old and Mr. Story was 48 years old. And the proof was that during this marriage, principally Ms. Story was the primary caretaker of the party's 11-year-old homeschooled daughter. Homeschooling the daughter, we think the proof showed that it was a marital decision. It was something that ultimately did affect Ms. Story's ability to generate some income because she was homeschooling the child. And it was going to affect her ability to generate income moving forward. And I think
did that have any effect on the trial judge's award of what would essentially be a part-time amount of money for her?
I think the award of the trial court made an award of 8 years of alimony in Salito, which pretty much coincides with when that minor daughter is going to reach majority. It seems like the timing was right on point for what the trial judge did.
And the trial judge awarded her $54,000 a year imputed, or he didn't award her, he imputed that amount. And that would be kind of if she had earned 80 before, that would be sort of a part-time amount. At $60 an hour, that's about a half year. We're getting close to a half year salary, right?
Yes, sir. That's, and the trial court didn't really tell us exactly how he came up with that number, but that's, there was some evidence in the record that would maybe justify why he came up with that number. I think the court realized that during this marriage that Ms. Story, that she was principally responsible for caring for the child, that, during this marriage, despite her high level of education, that was her role, that was her agreed upon role in this marriage. And as Mr. Hunt pointed out, there were times during this marriage where she did go out and work and generate significant income. And that was during the time frame that her husband, as Mr. Hunt said, had his license red flagged and he couldn't process any loans with Fannie Mae and Freddie Mac. He was having troubles processing those loans. So
what years were those? Did those years correspond with her highest incomes?
And I'm not equipped to say right now. I just don't know if it was very clear in the record what the frame was of that. I think the trial court realized that Ms. Story, that she was educated, that she was certainly employed as a nurse practitioner for portions of this marriage. But I think the court realized her earning capacity moving forward was seriously jeopardized. She did have a car wreck in 2014, and her testimony was, she's a nurse, a Vanderbilt educated nurse. She testified that her diagnosis was of a bilateral thoracic outlet syndrome. She had an additional diagnosis of chronic neuroinflammatory disorder. She described her injuries as causing severe pain from a nerve detachment, which results in her having limited use of her arm. She has an inability to lift weights. She has neck pain that she suffers from, muscle spasms that she endures. It limits her ability to type and use her hands for any significant period of time. And also she testified that she had a limited vascular flow. But most significantly was the testimony, I think, of Mr. Story, where he pretty candidly corroborated her testimony. He knew that automobile accident affected her. He corroborated her testimony about the nature and extent of her injuries. I think he acknowledged that her injuries affected her ability to do her job. And he corroborated his wife's testimony that overall that automobile accident affected in a negative way her ability to enjoy life. He testified to all those things. The evidence in the record that the trial court considered was as a part of her ongoing medical regimen. If we want to talk about is she a fraud? Is she a fake? Well, she had regular continued ongoing medical expenses of approximately $800 a month for her prescriptions. She had an average of $500 a month for infusion treatments that she was receiving. And of course, now she was responsible for her own health insurance premium, which is costing her $600 per month. Ms. Story, she testified at one point that this is the type of condition that could put somebody in a wheelchair, is what she said. I submit that the trial court made a finding that is really well supported by the evidence in the record, and that her earning capacity and potential has been reduced as a result of her ailments and injuries and limitations. The court did make that determination. And significantly, at the time of trial, Ms. Story had left the job, and she had no actual income at the time that we were trying this case. The trial testimony really gave no indication that Ms. Story's condition was going to get any better. And I think, as the court observed, and I think the evidence showed, it was a progressive condition that continue to move forward in a negative manner. The trial court, I'd submit, made several candid assessments of the evidence. The trial court knew and thought that Ms. Story was going to be limited in her ability to generate future income, but he still, as we talked about, assessed her with a fairly substantial imputed income of this $4,500 per month. And he made that finding despite the fact that in 2018, year to date, she made $5,700. Year to date, no, that was for the whole 2018. Year to date, at the time of trial in 2019, her income was $12,765. We made an exhibit, trial exhibit number 7, where that was Ms. Story's income and expense statement, and she conservatively estimated her expenses at $6,500 per month. So if you take her imputed income of $4,500, along with her $1,100, her spousal support award, and the $768 in child support, she's still over budget by a couple $100 each month, even with the imputation, even with the alimony, even with the child support. So the trial court heard a lot of evidence about Mr. Story's behavior, that his behavior contributed to the decline of the marriage. He had issues with pills, he had issues with alcohol, and generally he abandoned the marriage, when he would go on, what he called camping trips on most weekends just to be out of the house. We would submit
Their testimony about his expenses.
There is very little evidence about his expenses. We know he was paying toward the line of credit on the marital residence. He was paying the mortgage on the marital residence. And then he testified that he had a mortgage on his residence that he was living in of $1,500, but there really wasn't a wealth of evidence on what his obligations were. I think there was some scarce evidence about exactly what his obligations were. We would submit, based upon the evidence, that Ms. Story is an innocent spouse. She's clearly economically disadvantaged. She enjoyed a good standard of living during this marriage, as the trial court found. And then as a result of this divorce, at age 44, she was forced to move in with her parents. I think the proof was substantial that Ms. Story had a need, and likewise, there was substantial evidence that Mr. Story had an ability to pay alimony. Despite his testimony that he was on pace to earn $100,000 in 2019, the court found his income to be $7,900 per month as a mortgage banker. And the trial court's assessment of Mr. Story's income didn't even take into account the fact that he generated income from speculative houses. He would build spec houses. And he had done that throughout the marriage. And there's testimony.
So was that included in his estimate of income?
It was not. The trial judge didn't factor that in. And in 2017, the parties split nearly $50,000 from a spec project that Mr. Story was involved in. The house that Mr. Story was just moving into, maybe he had been in it at the time of trial or was just getting ready to move into it, was a spec project that he had undertaken during this marriage. And that had $25,000 worth of equity already in that house.
Now, he testified that he made something like $100,000. That's just from his job as a banker, right?
Correct.
And the judge didn't even assign that much to him. He assigned more like 80,000 or something, right?
Exactly. Yes, it was a lesser sum. It was a lesser sum than what $100,000 would be. Yes. And it didn't even, like we said, it didn't even talk about his spec building projects. I think overall the proof was.
Mr. Kersey, can you clarify something for me about this $90,000 debt and it becoming part of the alimony award? How does that work?
And that whole, I think Mr. Hunt said that his client agreed to assume that obligation. I think there was no evidence at trial of what that obligation was. It was unclear. It was unproven. It was unsubstantiated. There was no records or, bank balances or credit card statements to reflect what that sum was. My client, Ms. Story, testified that she had no idea what that possibly could be, that she was unaware of it. She might have been aware of a small portion, but nowhere in the range of $91,000. She said her testimony was she didn't make any charges on those accounts, and it was, there was nothing really to justify that, that award. I thought it was unusual the way the trial court, called that alimony in Toledo, because we really don't think there was any evidence to support that $91,000. So if the court was obligating my client to pay it, there was really no evidence of it.
And did the court order him to pay the debt to the creditor or to pay to your client $500 a month to satisfy?
No, I wasn't aware. No, I think that was paid to the creditor. My client got no payment for that.
Right.
It
So
was something he was supposed to hold her harmless, I assume, from the creditors.
but it became alimony instead of an allocation of a marital debt.
Correct. I assume that's how that's how it ended up. That was the net effect of it.
That helps my confusion. Thank you.
With respect to that disability insurance policy that Mr. Hunt was talking about, and there was nothing offered into evidence about how that policy would potentially pay off, when it would pay off, what exclusions, were in place with respect to that policy, or, how it would ever pay off. So there's really so little evidence about that. We think that the proof was that Mr. Story was healthy. He was able-bodied. He had a good future in the mortgage banking industry. He suffered none of the physical limitations that his wife suffered from, and he wasn't obligated to participate in the homeschooling of their daughter like my client was. And we think, when you take the totality of the evidence, we know the trial court has afforded broad discretion in its award of spousal support to include the amount of it, the duration, and the specific type of alimony the court awarded. We think that the trial judge properly considered the relevant statutory factors, and he made a ruling that was, well within the range of reasonableness, and respectfully, we ask that it not be disturbed on appeal.
All right. Anything further, Mr. Gursky?
No, sir. Thank you.
Hearing no questions, and we'll hear from Mr. Hunt.
Thank you. To address one of Judge Bennett's questions, the time period that my client was red flagged and was not able to do Fannie Mae and Freddie Mac loans was in the 2009-2010 time frame, and the car accident the wife was involved in, Your Honor, was in 2014, and then her two highest grossing years were in 2015 and 2016.
What about, did he do an income and expense statement?
Your Honor, neither party filed an income and expense statement with the court as part of this trial.
Okay.
And to address another question you had, Your Honor, the award of $7,900 a month is about $95,000 a year. And really the testimony at trial was somewhere that my client made $90,000 to $100,000 a year. So honestly, I think the trial court judge just basically split the difference and said $95,000 a year, and which is exactly what they imputed him with income. I don't believe anybody, either of the parties, refuted that was his monthly or his yearly income. It did fluctuate a little bit. He's in a bonus-driven industry, so some years he would get a bonus, he'd make more. Some years he was making $60,000 a year. So basically, that was sort of an average income.
So, and then he made money on spec houses, or hopefully made money on spec houses.
He did, Your Honor. To address that issue, the testimony was clear at trial that he had done 2 spec houses, sold both of those spec houses, as Mr. Gursky said, for about $50,000 and split that equity evenly with his wife. So in addition to all the other awards the wife received at trial, she had already received about $24,000 to $25,000 from the sale of those spec homes. In fact, I believe that Mr. Story was specifically asked at trial about whether he had any other spec homes or if he was still in that line of work, and he said no. So this was not some kind of side job that was an ongoing side job for him. Those spec homes were sold in 2017 or 2018, and he split that equity equally with his wife. So in addition to everything else the wife was receiving from this divorce, she'd also received that income or that division of equity along with her.
But he wasn't going to keep doing it.
He was not.
Mr. Hunt, can you explain how your client assumed the $90,000 debt as that he would be responsible for it, yet it becomes an alimony award?
Your Honor, I would have the same response probably that Mr. Gursky had to that issue. I'm not sure why that was not just allocated as debt to put in Mr. Story's column, for lack of a better term. I'm not sure why the court found that to be an alimony and Salido award. I will share with the court that it wasn't as simple as Ms. Story saying I didn't know about that debt. Clearly, my client couldn't maintain the same level of income when he was red flagged, and he took out debt because the parties were living above their means, as the trial court found.
All right. Thank you, Mr. Hunt and Mr. Gursky. You both did an excellent job of advocating on behalf of your clients. That concludes the case. Mr. Hibner.
This honorable court is now in recess until 2 p.m.